He'll be here too. Yeah. Okay. Very much so.
All right. Good morning, everyone. We have, make sure everyone we need online is online. We're good. Okay. A final plea calendar. If you are on the final plea calendar, you should know that if we don't resolve your case today, it will appear on the January 2026. That sounds far away. 2026 trial calendar. That's where we are now. Those cases will end up there. We also have a revocation matter, and Eugene Roberts is on the calendar again. Did we produce? Good morning, Ms. Nelson. We didn't bring him over again. Good. Okay. That just would have been,
No,
that might have been who that other guy was fighting with. So, okay. Who's handling the revocation matter? Because I think we've got the gentleman on from GDC, and I'd like to take care of that first since they were gracious enough to connect him. It's on the calendar as Poteet, but I think there's another name involved as well. Ashley Johnson. Okay. Either way, who is Mr. Johnson's lawyer?
Good morning, Judge.
Hey, Ms. Wood. How are you?
James Poteet. So I was a little so is his name James Poteet or is it something else?
Let's find out. He's on the screen. Good morning, sir. How are you?
Good morning. Fine.
Are you Mr. Johnson or Mr. Poteet?
I guess I have to go with a double jeopardy here. Both names.
Both names. Which would you like me to call you today? I'm happy to use either one.
Well, to call me Johnson because my name has been corrected to Poteet yet. So just call me Johnson. Okay, right. So then I will rather be called Johnson. Okay, so just one Johnson.
Johnson it is. Thank you, Mr. Johnson. So Ms. Wood, this is Mr. Johnson, and he is dialing in through a Department of Corrections link.
Yes, Judge. So I saw the note on the calendar for him. I represented Mr. Poteet way back when for the plea. I want to say we did a drug court plea, and I'm assuming that didn't work out. And so I was confused because I think the note that I saw said that he couldn't be housed at the current facility that he was at because of some health issues. Is that correct?
I think that's right. I think, and Ms. Simpson can help us out here, that maybe he was terminated from drug court and sent to a detention center, but that's not a facility that makes sense for him.
Yeah, they said his mental health was more extreme than they would be able to handle.
Okay, and so do we need to just modify the revocation?
Yeah.
And to get him, just have it be a straight revocation so that he's in GDC custody, they have a broader spectrum of care. Okay. So Ms. Wood, I don't know if you were able to hear Ms. Simpson, but I think we're really, I'm pulling up the case now. The idea would be to modify the revocation and convert what would have been time at a probation detention center into just a straight revocation so that Mr. Johnson, is what he asked we call him, can be given the appropriate level of care.
Yes, Judge, and I have no objection to that.
All right. Well, let me get his case up and then we'll talk with Mr. Johnson and that may take care of his situation.
Just to clarify, I am sending you the amended order, right?
Meaning if we amend it, you'll send it to me? I think so. Let's see what his case says. It's got my name on the case, so it should come to me. So it looks like in May, Mr. Johnson was terminated from drug court. Oh, so Judge Krause handled that, but yeah, it should come to me. And she revoked 7 months, and it was to be at the detention center. So my proposal, Ms. Wood, is to file an amended revocation order where everything is the same except we simply uncheck the probation detention center box. And it goes to, and we check Georgia Department of Corrections. So same duration, it will be nunc-pro-tunc back to May 5, all that kind of stuff.
That's fine with us, Judge.
Okay.
She included a $200 restitution with a minimum monthly payment of $10 to start 6 months after PDC. Do you want to include that or?
I don't want to change that. I guess that's for an ankle monitor. So we should, yeah, so we'll leave that, but it would be monthly payment after completion of the revocation. Okay. Mr. Johnson, you've been listening very patiently. All I'm going to do to your revocation order is just, it's going to be the same duration. You'll get credit for all the time you've been serving. And you're almost done, based on my math. And we're just going to make sure that for the last little bit of time that you're in, you're going to be at a facility that is safe for you. Okay? Any questions about any of that?
You're about sending me.
Say that again?
You say you're gonna send me to another facility?
Nope, I don't know that you'll need to move at all. It's just that you had, the judge who sentenced you had tried to send you to a facility and it wasn't one that was the right one for you. Okay? Do you have any questions about anything?
Okay, so you me Georgia State Prison, right? Till I get released.
Probably so, because you don't have much time left on your sentence. You'll probably stay where you are. Okay, do you have a place to stay when you get out?
No, sir. I'm gonna try to go to San Diego, go to the shelter.
San Diego, California?
Yes.
Okay, well, is he on probation in Georgia? Yeah, you don't want to leave the state so quickly. Make sure you talk to your probation officer before you head out of Georgia, okay?
Okay, great.
Sounds good. Well, thank you, Mr. Johnson, and thank you, Ms. Hemmings, for connecting us with that facility. All right, Mr. Johnson, you're good to go. You can head out.
Okay, thank you, sir. Yes, sir.
All right, have a great day.
Thank you, Your Honor.
You're welcome.
Yeah, have
Okay.
a great day.
You too. So you'll get that to me and we'll take care of that. Thank you, Ms. Simpson. All right, our final plea calendar, positions 1 and 2 are Winfred Sherman.
Judge, he's mine.
Is this the gentleman who tried to enter a plea basically like on arraignment day?
Yes, Judge, that's him.
Okay.
I'm anticipating, so I think this is just a final plea hearing, but once I get in the courthouse, I just want to speak with him briefly just to confirm that nothing's changed for him.
Okay, got it. And Ms. Smith, these are your cases?
Yeah.
All right. As I recall, these are 2 shootings. Okay. Position 3 is James Linzer.
Morning, just Bernie Ray Lale here.
Hey, Mr. Lale.
You said that.
You're right there, Mr. Linzer. Okay, what are we doing today?
Ms. Smith and I have spoken. It's my understanding that she's going to re-indict this case.
Yes, Your Honor, we have some evidence regarding, what happened in this case, and we'll be re-indicting both this charge and an additional charge. So we'll just be asking for a reset in this case to give us time to re-indict that additional charge.
Okay, so the re-indictment, would keep this same number, it would be a -01, adding any defendants, or it's just Mr. Linzer?
It'll just be Mr. Lancer.
And the terroristic threats count stays, and you're adding an additional count? And you've talked with Mr. Lael about what that's all about? Okay. This is conduct that's now about 2 years old. The incident, it looks like the incident was in November of 23. Whoops, never mind. I'm looking at the wrong case. Scratch that. I was looking at Mr. Poteet's. Thought I had already called up this case. Right, April of last year. Okay, so you'll be adding a, now, got a couple other things I want to make sure we talk about. Mr. Lael, you filed a motion to withdraw,
Yes, sir.
and you are still pursuing that?
Yes, sir.
Okay,
10 days ahead of mine.
okay, but we should talk about that a little bit, and bond and all that. Mr. Linzer, are you still on North Side? That can't be a good address. Where'd you go? There he is.
1700 on Side Drive.
That's it? No apartment number or anything?
No, sir.
What's there?
It's my office. I'm where I'm living.
Okay, but mail sent there goes to you.
Yes, sir.
Okay, all right. That seemed like such a round number that it would be a big building and would have an apartment or something. All right, Mr. Lael has filed a motion to withdraw. Sounds like you and he have reached sort of a financial impasse. He's entitled to do that. You're entitled to object if you think, no, I've paid him and this and that. Mr. Lael pointed out, it really hasn't been 10 days. It's close. We're at 8. But rather than make everyone come back in here, I figure we could have a tentative conversation about it. Are you resisting his withdrawal, or you understand why it's happening and you understand that you'll either need to get new counsel, or if you qualify, get a lawyer appointed to represent you?
If me and him can't work out, we're trying to work it out.
Okay, so you and Mr. Lael are still talking. If it doesn't, okay, and he could always withdraw his motion to withdraw. But if he doesn't do that, you will be bringing someone else on board? Okay. Well,
And I'll make sure that lawyer, if that happens, I'll make sure the lawyer uses all the discovery I have.
good. Well, I assume there's going to be something new too, unless what's in the discovery has generated the additional. What's the additional charge going to be?
That's why I say.
Okay. All
And
right.
the additional, discovery that they continue to return.
Okay. And it is the same incident, or are you putting together two different incidents in one indictment? Same incident? Okay. All right. One last thing, and then we'll talk about when we'll see everyone again. So your bond is that you are supposed to stay away from Nyla Brown. Have you been doing that? Okay. And that's the main condition. So, as long as that's not getting in your way. Now, here's an issue. Let's talk about it in case you stay on the case. If you reindict and you add a charge, Mr. Linzer is going to have no bond on that charge. That doesn't trouble me because there's a bond here. I'm assuming you're not going to get a grand jury warrant just for adding a count of theft by taking.
The intention was for the charge here and the new charge to be indicted together.
Mhm.
And once that is indicted, then this case will be no problem.
Okay, I'm following you on that, but Mr. Linzer has a bond for terroristic threats. If you reindict, there's a superseding indictment, then he'll have terroristic threats and theft by taking. There'll be no bond for the theft by taking charge. I just want to make sure you're not intending to, sometimes a prosecutor will get a grand jury warrant. In particular, if the charge you're adding was more serious, if you're adding a murder charge, I would hope you'd get a grand jury warrant and Mr. Linzer would go into custody. We have another bond hearing. Maybe he'd get a bond, maybe he wouldn't. but what you're adding doesn't sound like it's necessarily more serious than the terroristic threats. It's intertwined with it. So I was wondering if you'd be comfortable assuring that you don't intend to get a grand jury warrant.
Not at this moment, Your Honor.
You meaning you don't intend to, or you're not comfortable assuring me that you're not going to?
At this moment, I'm not comfortable assuring you that we will. not.
Okay, well, make sure you talk with a supervisor before you haul off and get a grand jury warrant on a theft by taking addition to a terroristic threats count. If you null pros the older indictment, which is what I'd expect you to do at some point, if you do it right away, then there's actually no bond at all in place for Mr. Linzer. And so there would be no enforceable stay away provision.
Right.
And so we just need to work through the bond piece. I'm not worried about him disappearing, but when the DA's office reindicts, it hasn't always followed the same path of, yes, we get a grand jury warrant or we don't. And I'm less worried, now that you told me what you're adding, but if what you were adding were a series of serious counts or maybe another victim, then we do need to do something about bonds so that there are conditions of stay away from that victim as well. So just practice pointer going forward. I'm all for reindicting if it cleans up the case and makes it fit the facts better. But your office, and I was talking with Ms. Peterson about this, they need to be thinking about what are you doing with a grand jury warrant or what's the situation going to be with bond. This giant gang case that you were sitting in where Mr. Abate was here, Mr. Howes he's indicted this guy for 2 murders now. He actually doesn't have a bond. If he could walk free, there's not a bond that's holding him on some of those other charges. Not your problem on that case, but anyway, Mr. Lael, will you let Ms. Nelson know, that's my litigation manager, know the outcome of your conversation with Mr. Linzer? Because I will sometime next week grant your motion if I don't hear anything. So I guess it should be only if you two work something out, either file a motion withdrawing your motion to withdraw, or at least let Ms. Nelson know, because I'm making a note to Monday or Tuesday of next week. If there's nothing else in the docket, I'll enter an order that takes Mr. Lael off your case. And then Mr. Linzer, you'll need to get the attorney you're bringing in to file an entry, which gets me then to our last point, which is timing. When do you think, Ms. Smith, you'll be reindicting?
We intend to have it reindicted by next week.
Okay, and we is who?
Myself, and I'm also working with Mr. Ansel.
Oh, okay, got it.
We'll get that, we're getting some additional documents.
Okay.
To be investigated and be indicted.
Okay, but you or a colleague would get in front of one of the grand juries next week. All right. Then what we'll probably do, Mr. Linzer, is put your, you have to be arraigned on the new charges. It's going to seem kind of like a formality. You already did it here, but there's a new count. But we'll try to get that in the next couple weeks. You'll need to be here unless your lawyer, Lael or otherwise, files a waiver of arraignment, and then we'll just get this back on track to whatever the resolution is going to look like. Any questions about it? I talked a lot. Any questions? Okay.
Just for the record, Ms. Smith, I would just, if there's any way we really got this case, not, so my client didn't have to turn himself back in and make a bond on the theft charge, I appreciate it. It's not we do that, okay? Thank you kindly.
Yep.
Okay.
That was my nudging as well, but I appreciate you may need to talk with the supervisor about how that's going to play out. And Ms. Peterson, up at this level in your office, has been nudged by some judges to say, hey, when people are reindicting, they need to be figuring out, are they doing a grand jury warrant or not? I don't know that this is the right case for one, but that's a DA's office call, not a judge call. If there's nothing else, Mr. Lael, you and Mr. Linzer are free to go.
Thank you, that's all I have.
All right.
Mr. Vice President, and to be.
Mr. Abadi? Okay. In 2B? Okay. All right, Mr. Morera, and he is on Zoom. And Ms. Rios is on Zoom. Let's get Ms. Rios. There's Ms. Rios. And how do you pronounce your client's last name?
Eric Morera. I think I'm pronouncing it right.
All right. Mr. Morera, can you please turn your camera on?
I'm having troubles turning on my camera. I'm not really sure what's going on right now.
What device are you on?
I'm on a laptop.
Okay.
Is it on?
So if you're on Zoom, is there not just a little video icon you can click?
Yeah, it's taking me to my settings to turn on allow the camera thing, but it's not working. Hold on, give me a second. Cause I see the icon where I could press it, but it won't let me press it.
Okay. Well, let's see what we're doing today, and we'll figure out if you can stay with no camera on, or if you're going to need to get a different device or come on down here. Ms. Rios, this is final plea. Tell me what the plan is.
Me and the state have worked out a virtual PTI where he completes 60 hours of community service within 3 months, and then the case will be non-prossed. So,
who have you been talking to from the DA's office?
Mr. Hiles before he went on leave. And then I spoke with the person covering from him, which was Miss Ockham. Am I saying that? And
Ms. Ockham. Yeah.
Ockham, that she would honor what me and Mr. Hiles had worked out.
Okay. Can you put together a proposed order for the pretrial diversion with those terms spelled out? And if you email that to me, Ms. Nelson, and Ms. Ockham, she'll have a chance to weigh in and say, yes, that's consistent with what we negotiated. And then I can sign it, which would put Mr. Morera's case in judicial hold for 3 months to take care of that community service. And then we'll just get him on an inquiry calendar 3 months out to make sure he did what he said he was going to do.
Okay. That sounds good. Is Ms. Ockham on or?
So, good morning, Judge. ADA Smith was filling in for DDA Ockham, but the terms, as stated, are accurate, Your Honor.
Okay. Should Ms. Rios send that proposed order to you?
She can send it to myself, copy myself and DDA Ockham.
Okay. Mr. Morera, do you understand what you're agreeing to?
Yes, I do.
Okay. How much community service?
60 hours.
Yeah. And you're going to finish it how quickly?
In 3 months.
All right. Any ideas where you might do that community service?
Not yet, but I have heard there are plenty of places around me.
Well, there are lots of places. And where is around you? Where do you live?
Right now I'm staying with my grandparents in Winder, Georgia.
In Winder?
Yes.
Okay. Well, there are plenty of places. Two important things about this community service. One, it cannot be for a family business or a family friend. It would need to be at a church or a youth center or wherever. And then number two, even more important, you need to be able to document it. So it's not just that you send a letter to Ms. Rios saying, I did it, but for whatever organization you're doing it, let's say you do a food pantry at a church or something, they're going to need to be able to log in on November 8th. Mr. Morera was here for 6 hours, signed by Pastor so-and-so. So make sure you document it because the prosecutor is going to need to see that documentation at the end of the 3 months or however quickly you knock it out. Otherwise, you're going to have to do it all over again to get paperwork for it, okay?
All right.
Any questions?
No, I'm good.
All right, Ms. Rios, do you have good contact information for Mr. Morera?
Yes, Your Honor. And Mr. Smith, what's your first name so I can send the email?
I'll put it in the chat for you
Okay, thank you.
and the email as well.
Thank you.
Okay. So Ms. Rios, we'll look for that proposed order, assuming it gets the green light from the DA's office. That will take this off calendars for 3 months, and Mr. Morera can make it all go away if he takes care of that community service. Any questions, Mr. Morera, beyond what we talked about?
No, I'm good.
Okay, figure out how to use your camera. You're good to go.
All right, thank you.
Thank you, Mr. Smith, for dropping in on this one.
Thank you, Judge. And that concludes my business. May I be excused?
Yes, sir.
Thank you, Your Honor. You have a good day.
You too.
Okay.
All right, Jason Bates. Mr. Bates is here. Oh, I should have left you on the screen, Ms. Rios.
I need to talk to Mr. Bates. I have not had communication with him. The phone number that I was trying to reach him at wasn't working. Mr. Bates, do you still have my number?
Oh, no, I need it now.
Okay, I'll tell you what, if you put in the text your phone number, Ms. Rios, I'll write it down and Mr. Bates will step outside and give you a call.
Okay.
All right. Mr. Bates, did you have a phone number that you gave to Ms. Rios and it's changed, or what happened? Okay, well, I'm gonna give you her phone number and you can call her and then we'll have more of a conversation. Ms. Smith, this is your case? Oh, okay. Deputy Gordon, you mind getting this? So if you'll call Ms. Rios now, you guys, well, let me make sure. Do you have any other cases on the calendar, Ms. Rios, or should he call you now?
I have no other cases. Yes, you can call me.
Okay. Ms. Smith, did you get we're talking about position 5. Did you get an offer to Ms. Rios in this case? Okay, great. All right, Mr. Bates, come back in after you guys are done talking. Roderick Williams.
Who's my judge?
Hey, Ms. Wood,
Oh,
you're here.
I need to speak with him. We've been talking with, the state, and I just need to give him the most recent update.
Okay, we will circle back. Corey Comer.
Savannah Smart from Ms. Williams, Mr. Comer. I did send an email, to Mr. Harper yesterday. I did that. She's been on leave.
Ms. Williams has.
Yes.
Okay,
A little bit. So I'm not fully updated. I was trying to reach out to see what was going on. She speaks to the state, I believe, and
Okay.
it's also in custody.
he is. He's here. He's up, so you can chat with him. Are you co-counsel with Ms. Williams or, okay, great. Would Mr. Comer ever have seen you before, or this would be the first time?
No, I heard the preliminary hearing, we were here for that.
Okay, so he'll recognize you. All right, well, why don't you and Mr. Body speak? It's final plea. Given his charges, we don't often get a lot of traction in cases like this, but we need to make a record of whatever the state's offer is. You let me know that there aren't discovery issues or there are discovery issues, and we go from there. Is Ms. Williams expected back anytime soon?
Tuesday.
Okay.
So we're doing a cash, it's been about 2 months.
Okay.
So we're doing cash up right now.
Okay, I asked because she has another case in here. It's a big gang case.
Know which one
I do, and I'll give you we need a hard drive from her, so discovery can be put on it.
That's getting built out today.
Oh,
If I'm
good.
not mistaken.
Okay.
Was that Chambliss?
Yes, yes, yes.
Dropping that off today.
Okay, excellent. She and one other lawyer, everyone else they got their hard drives in, but we had 2 folks. I didn't realize Ms. Williams had been out. And she waived arraignment, so that's all. I think she waived arraignment. I gotta look at my little chart. Okay. Okay, so you and Mr. Body can, we're almost done with the calendar. There's one more position. So after I call that, you guys can speak. At some point, we'll bring Mr. Comer out, even if it's, I don't want to take life without parole, but we'll get that on the record. Okay? All right, thank you. And finally, Ronald Jones. Mr. Jones is here, Mr. Webb is here.
Good morning, Your Honor.
Good morning.
We would like to have an opportunity to speak with the state. We received an offer and we're in negotiating mode.
Okay, well, the state's here. So it sounds like there's going to be some conversations. I am available. I'll come back out after there have been conversations to see, do we have some pleas today? Folks should know, if you are thinking about, do I work it out today or not? The main thing that changes after today is if you enter a plea after today, you can enter a plea in the middle of trial. You do not get to withdraw your plea if the sentence that I impose is more than what your lawyer asks for. Today, if Mr. Webb were to say it should be 4 years probation, and I said 5 years probation, that's more than what Mr. Webb advocated for, and so Mr. Jones could withdraw his plea. But after today, if there is a plea, the sentence is the sentence, and that's what we go with. Okay? I'll be back out when you guys let me know. All right. Let's review. Mr. Sherman would be first, but we don't have to take it in that order.
It's just gonna be a final plea hearing, and so whenever Deputy Gordon is ready for him.
Okay.
Mr. Williams if needed.
Let's see, Linzer, we dealt with. Mr. Bates is here. Did you get a chance to talk with Ms. Rios? Okay, she's gonna pop on. There's Ms. Rios. Hey, Ms. Rios, what are we doing with Mr. Bates?
If we can go to the trial calendar and preserve his final plea rights, since this is the first time I've been able to talk to him and I haven't been able to go over all of the discovery, and there's some videos that I would like him to see. The police reports were unclear of how he was connected, but a little bit was more clear based on the body cam. And so I would like for him to come to my office and look over stuff before he has to decide whether he wants to enter a plea in a lengthy prison sentence today.
Okay. And tell me how was it that you and he were having trouble connecting? Just the number you had for him wasn't working?
Yes, Your Honor.
Okay, but you now have a good number for him?
Yes.
And you've got Ms. Rios's number. So if your number changes, you still know how to reach her. Are you Mr. Bates? I got two different addresses for you. One's on Glen Street, another one says North Avenue. Apartment 166? Okay, good. So you're getting stuff in the mail. And let me see one other thing. Ms. Smith, what was the offer that you communicated to Ms. Rios? Okay.
The offer for this case, Your Honor, was 15, served 7, now, okay.
Okay.
Presumed condition for probation.
Okay, got it. Mr. Bates, you're supposed to be staying away from a Joyce Caldwell. Do you know who that person is? No? Okay. Ms. Rios, is it your understanding that this is a stranger on stranger situation?
Yes, Your Honor.
Okay, got it. Then that makes it easy. You wearing an ankle monitor? Okay. So your request, Ms. Rios, is basically keep this on that January trial calendar, but preserve Mr. Bates's final plea rights.
Yes, Your Honor.
Got it. That works for me. Ms. Smith, anything you want to add?
No, Your Honor.
Ms. Rios, do you feel like you've got all the discovery as best you can tell?
I think so. Some stuff is a little unclear because the police reports that I have are a little incomplete just because it was a little unclear based on that, like how they were connecting him. So I'm not sure if there's a supplemental report out there that makes everything a little bit more clear, because I know they went out and talked to a woman on the scene, a grandmother who said she saw some stuff, but that's not reflected in any of the reports. So I was going to email to see if maybe I'm missing something.
Okay, well, why don't you confer with Ms. Smith, and she can look as well, or you guys can compare files. I'm going to assume we're good to go, though, and that supplemental, you're certainly entitled to it. That's just not something that would probably result in a suppression motion or anything, so that we can assume the January, I think it's January 8th, January 8th date is a good one for everyone. All right, I think that's what we'll do. Mr. Bates, do you have any questions? So your next step will be to meet with Ms. Rios so she can show you the evidence in the case. And I will see you again no later than January 8th, so early next year. If you and Ms. Rios work something out before then, we can always come on in, but otherwise it'll be January 8th. Ms. Rios, you need anything else for Mr. Bates?
No, Your Honor, thank you.
All right, Ms. Smith, anything else?
No, Your Honor.
All right, Mr. Bates, you're good to go. Okay, you too. Roderick Williams. Hey, Mr. Williams, come on up, please. Ms. Wood, what are we doing today?
Just the final hearing, Judge.
Okay. Do you feel like you've got the discovery in the case?
Yes.
All right. Ms. Smith, what is the state's offer if Mr. Williams wanted to resolve his case today?
The current offer in this case, Your Honor, is 10 years probation total, a breakdown of the counts, 5P for count one, 5P consecutive for count two, and 5P during concurrent count one, count three.
Okay. Any particular conditions of probation?
Yes, Your Honor, it's for the defendant to have no contact at all with the victim. Also for the defendant to stay away from the incident location, not just the apartment that the defendant stays in, but
The whole building?
Yes,
Yeah.
the apartment complex itself. For the defendant to complete 100 community service hours, be gainfully employed, and to show proof every 90 days to obtain the GED if he's not already obtained the GED or graduated from high school, to complete an anger management course, and also to have a Fourth Amendment waiver on file.
Okay, got it. Mr. Williams, I'm hearing the state say that if you wanted to enter a plea today, that they'd be recommending probation. It's a bunch of probation, but it's not jail time. I understand, 10 years is long. Ms. Wood could always argue for something less. She also could advocate for what we call a behavioral incentive date, which is a deadline that I would set. And if you had done everything you were supposed to while you were on probation, then probation at that date looks at things, and if all is well, they can close the case out. So there are variables in there that can shrink the 10 years down, but that's what the state would be recommending. You understand that today, if you decided to enter a plea, you could withdraw your plea if I sentence you to more than what Ms. Wood asked for. You understand that? Okay. You have a question? What's your question?
10 years for an argument, they're
Okay.
So people get offered different things. You heard the gentleman who just left the offer was 15 years to serve 7 years with a balance on probation. So that sentence is 5 years longer than this one, and it involves 7 years in prison. Yours involves none, but if the facts of the case are, in fact, there was just some jawing back and forth, you've got a great lawyer, she can take it to trial, and a jury would decide that was just people talking to each other and there was no gun involved or anything like that. The allegation is that you had a gun and you're a convicted felon. I'll tell you, just real basically, if you had a gun on you in any way, shape, or form in this situation and you're a felon, that's a pretty easy one for the state to prove. And then you're guilty at count 3, and the jury might be thinking, why do we believe him about anything else? But you and your lawyer will talk about that. I'm focused on whether you're working the case out today or you want it to go to that January trial calendar. And it may still not be a trial, you may work it out, but you're moving in the direction of a trial. That's what you want?
Yes, sir.
Okay. Last thing I need you to tell me you understand. You might decide tomorrow, wake up, I don't want to go to trial, let's take a plea. You may decide the day of trial you want to plead, and you can plea anytime. I can't stop that. What'll be different then is that you don't have the ability to back out of the plea if you don't like your sentence. Today, if Ms. Wood asked for 5 years probation, and I went with the state and said 10 years, you could say, nope, I was willing to do 5, not 10. No, thanks. I'll see you guys in January. After today, if I sentence you to 15 years probation for whatever reason, that's your sentence. You don't get to say, well, wait, Ms. Wood asked for 5. You gave me 15. Do you understand what changes after today? Okay. Understanding that, you'd like this to go to the trial calendar? Sounds like a plan. Ms. Wood, you've got good contact information from Mr. Williams? Mr. Williams, do you know how to reach Ms. Wood? Excellent. We'll see you January 8th. Mr. Comer. Should we bring him out?
Yes, I think you do.
Oh, he didn't want to come out? Oh, well, I don't want to force it. Maybe he just come to the door. I can say, hey.
Oh, that's fine. We don't, yeah, I mean, either.
I just need to get on the record. He's saying no, thank you to the state's offer.
That's what we're doing.
Okay. Morning, Mr. Comer. come right on up there, stand next to your lawyer, Ms. Smart. We're going to get on the record in your case, which is 25 SC 001926. Today, Mr. Comer, is a day where if you had decided that you wanted to enter a plea, you could, and you'd be able to withdraw your plea if the sentence that I gave you was more than what your lawyer asked for. In your case, that's a little complicated because some of these charges carry, as you know, pretty serious sentences. And so we don't often sort things out on a day like today, but I need to make sure we get all the things on the record that we need to. So I'm going to start with Ms. Smart. Is it your sense, Ms. Smart, that you and Ms. Williams have all the discovery in this case?
Yeah, it's Smart, I apologize, Judge. And yes, I've spoken with the state. It's, I believe the only we're waiting on is the ballistics.
Okay.
I believe we should get in December.
Okay, they're probably waiting on them as well then. So tell me, how do you spell your last name?
SMARCH.
Smarch, like the month with an S in front of it. Smarch. Okay, Miss Smarch. Short of the ballistics, which no one has yet, you feel like you've got everything.
Yes.
Okay, good. Well, trial wouldn't be till January at the earliest anyway, so we ought to then have the ballistics. Mr. Abadi, is your read of the case that ballistics are particularly determinative in this case, or it's not heading that way?
Other than connecting the two, murders, no.
That the same weapon was used in both shootings?
Yeah.
Okay.
But I've been calling things problems, but.
Okay, I wasn't pressing on that front. I just was curious if that's one where one of the two sides is going to say we absolutely positively can't go forward without ballistics because it shows it was a 9mm and Mr. Comer had a 380 in his hand, and then he wasn't the guy. Okay. What is the state's offer at this point if Mr. Comer wanted to resolve this case short of trial?
Offered the mandatory minimum, which was life plus 5 years for the firearm for both the homicides and everything to run correct.
Okay. So Mr. Comer, what the state is offering is a long sentence. It's life plus 5, but that's life with parole, which is pretty different from life without parole, which is a sentence you would be eligible for if you go to trial and a jury finds you guilty. I don't know anything about your case, how strong it is or weak it is for the state, but you should understand that if you go to trial and a jury does find you guilty of one or both of the murders, then the state could ask for, and even if they don't ask for it, I could impose a sentence of life without parole. That's as long as it gets. That means you never, ever get out. With a life sentence, you are eligible for parole after 30 years. That's also a long time, but there's a difference between you could be considered for parole and you never could be considered for parole. So I just want to make sure you understand the difference between the two. You do? Yes? Okay. Are you interested in moving forward today with, it's basically a plea to the indictment. You'd plead guilty and the state would recommend life plus 5. Is that something you're interested in doing? No. Okay. I fully understand that. We'll move your case to the trial calendar in early January. And it sounds like the only thing that would trip us up for not being ready then would be whether the ballistics evidence is available from the crime lab. And I know the prosecutor is pushing them on that. I also know there's a long line of cases they're working on. You'll be brought over here anyway for that. And we'll talk about what's going on January 8th. Between now and then, Ms. Smarch and or Ms. Williams will be talking with you, especially if it looks like this is the one going to trial. They're going to want to be getting you ready for that. All right? Any questions about anything? All right, Ms. Smarch, anything else on behalf of Mr. Comer?
No, Judge.
Mr. Abadi, anything from the state?
Your Honor, they just actually emailed me, they're targeting December 1st, so we both want to have.
Okay. Are they ahead of Denike or after Denike?
They are.
Okay. All right. Thanks. See ya.
Thank you, Judge.
So we have left Mr. Sherman, who I think is a no thank you, and then we'll figure out what we're doing with Mr. Jones.
It will be a plea, Your Honor.
Thank you, Mr. Webb. I was hoping we get one today. I knew you'd come through. I don't see Ms. Willingham. You beat her down so bad she's not even coming back in. All right, let's bring Mr. Mr. Sherman. Yes, sir. Thank you. We're ready for Mr. Sherman when you guys are ready.
Thank you.
And Ms. March, you believe that someone's dropping the hard drive off in the Chambliss case today?
I physically handed an investigator one yesterday.
Fantastic.
Thank you.
Will you be working with Ms. Williams on that case?
Possibly, likely. It's just the two of us, so we.
Oh, so you guys are tag teaming everything. Okay, great.
Thank you, Judge.
You're welcome. Good morning, Mr. Sherman. I'm okay. Good to see you again. We're going to get on the record in your two cases. It's 25 SC 002841 and 25 SC 002842. I remember you and the cases because you tried to enter a plea a few months ago at arraignment, and I learned a little bit about them. They both involve shootings or alleged shootings. You were not interested in the sentence that I imposed, and on that date, you were free to withdraw your plea. We are at the very last day where you can withdraw a plea if you don't like the sentence that I impose. More importantly, if the sentence I impose is more than what Ms. Wood asked for. After today, we get you to a trial calendar. That doesn't mean you have to go to trial. It means if you decide to plead after today, whether it's tomorrow or the day of trial, you can't withdraw your plea. If you ask through your lawyer for time served, because you've been in for a long time, and I give you something more than time served, that's just sort of what you're stuck with. Just like if you go to trial. If you go to trial and a jury finds you guilty, you don't get to say, I don't want that sentence. If it's a legal sentence, that's the sentence you get. Of course, if you go to trial and jury says not guilty, we're done. And unless there's anything else holding you in custody, you go on your way. Ms. Wood, do you believe you've got all the discovery in both the cases? Ms. Smith, is there any discovery you are thinking you don't have yet, the state's still trying to get, that then Ms. Wood would get?
I'll have to double check right now. I think we're good to go.
Okay. What's the state's offer to resolve the two cases?
The offer in this case, Your Honor, was adopted from Your Honor's sentence, recommendation from the plea and arraignment calendar, which was 10 certified with the balance from the various probation.
Okay, all right. So Mr. Sherman, the state's recommending the sentence that I felt was appropriate based on what I learned about you and the facts of the case, et cetera, which is 10 years to serve 5 years. You'd get credit for all the time that you've been in. It is not a recidivist sentence, which means you'd be parole eligible, but it does mean you'd be in custody for a while longer. Do you feel like you understand what the state is recommending? Yes. All right. Are you interested in going forward with a plea today, or would you prefer that I move your two cases to the trial calendar? We'll do that. That trial calendar is on January 8th. So you'll be back here on the 8th. 8th isn't when we start trial. It's when we figure out of the cases on there, which one is going to go to trial. Yours will be high up on that list because you've been in jail for a long time. And we'll figure out then, all right, you serious? You really want a trial? You want the jury to come hear all this? Or I thought about it more, Judge. I want to work it out. And then we'll take a plea. Either way, you'll be through Ms. Wood making those decisions. Any questions? All right, Ms. Wood, anything else?
No, Judge, thank you.
All right, Mr. Sherman, we'll see you on the 8th.
Your Honor, I can excuse me, that was my last matter.
You're quick to get out of here. But yes, I think Ms. Willingham, but you need to find Ms. Willingham. She's with Judge Barwick. She is coming back. Okay. That, you mean, you don't need, I mean, you, unless you're going to take the plea for her, then you don't need to stay. I just want to make sure she was coming back, and it sounds like she is.
Yeah, be excused.
Yes, ma'am. Fill your pockets and then you can go.
Judge, under the consolidated calendar, I
Yes.
think the number 1 slot is for sure going, according to my colleague.
Meaning Judge Edwards's case.
Yes.
I was told that was likely too.
Yes, so of course, Mr. Leek and I will be there, but I was wondering, will that one likely be on our next trial calendar here?
That's a good question. Well, it will certainly come up week 2 in the consolidated calendar, and it will move up one because then if Judge Edwards's case goes away, she doesn't get to have a second one before we get one. So Leek will slide up, although Leek is behind Dean, and unless Horsley's not able to do it, Dean would go before Leek. But we'd move up one. McAfee is going to be trying the case that's on the list, so he gets out of the way. So actually, we move up 2. But I think there was one case ahead of Dean, but after the Edwards case. I don't remember the name, but I'll tell you. Emerson. So Britain is that case. There's a case called Charles right after it, and then Emile, which is a Barwick case. Lethbridge continued hers. There's Dean. Then there's a McAfee case that he's trying, and then there's Leek. So Leek will move up a couple. It'll be on that second week. My guess is it also won't get reached. And then we do need to address your question, which is, all right, well, what about in here? He's in custody?
He's out of custody.
He's out of custody. Okay.
2022 incident.
It's old, and I want to be clear, I'm not delaying it because of this woman in Colorado who won't come here. We will need to add it. I think though our December calendar, we have a specially set December calendar. Do we have a separate one too? Yeah, well, it's for that pool case, which will likely go out. That's a retrial. It's a vehicular homicide that we tried before, 100 miles an hour up the Lenox Mall off ramp. Didn't end well.
We don't have a second trial calendar for December, Judge.
We do or do not?
Do not.
Guess we're taking it easy the rest of December, huh? Merry, happy holidays. Happy holidays to everyone. So then he would go on the January 8th.
Okay, that's fine. Because I have a habeas coming up that I think falls in the second week of the consult.
Oh, well, that's a good question. Habeas as in you have to go testify somewhere?
So they told me I was gonna have to go to Wilcox County, but then the.
I thought they let people Zoom in.
Yeah, they just emailed me.
Good.
Actually, it's gonna be Zoom.
Good.
It's in the morning, so if I am on trial, it just needs to.
Okay, but you raise another avenue for leak, although we could add, do you think that Mr. Sherman's going to be a trial?
I don't know.
Okay, all right, because we could put Sherman, there's the December consolidated calendar, and I have to put 2 cases, I get to put 2 cases on there. We could do leak again.
Do Vengeance Command stuff.
Oh.
If we don't reach that in November. That's friend with the ice hole.
No, I know who that is. Is that one require interpreters? That was a question Ms. Nelson asked. Okay, so we need interpreters there. That would be a great consolidated trial calendar case. But that really hinges on whether tonight we can convince Grumpy to go forward. Okay, all right.
Thank you, Judge.
Thank you.
Have a good weekend.
Mm-hmm.
Judge, did you have any cases for these?
Do I have
Please, 196.
the trial calendar?
No. That's actually. The judicial special day.
Oh, yeah, Ms. Rios, I think, does. Let me bug Ms. Wood to confirm that. Can you speak on behalf of your trial partner? We've got this Thursday the 6th. Leadership Atlanta is coming in. Yeah, and Ms. Rios said, I got the $1 million, please. And I said, we can't do $1 million. We have an hour with these folks. But she said, I've got at least one who's in custody and maybe one that's not, which is a good balance. Do you have any update on that? I'm gonna have to shoot her an email.
I don't know about hers, Ms. Smith and I was trying to get Crystal Alexander.
That would be fascinating.
I thought that would be a good one.
It would.
I missed that one.
And she's in custody now.
Yes.
Woo. Okay.
Yes, yes.
Well, you guys arm wrestle. I need 2 pleas. We have an hour. 2 pleas will do it because then did you do this last year? And then have 1 million questions for everyone.
I didn't do it last year, but I've done it before.
Okay, it's very helpful to have you have a defense attorney and a prosecutor here to engage with the group afterwards. So it can be a Rios and a Wood, it doesn't matter, but let's just make sure. Thank you for flagging that. I'll remember to send an email out to say, hey, we need to do something.
Are you involved with whatever their presentation is outside of here, or are you like around that day? We just need to for them to watch.
So both, I have to be at the, whatever the Cop City is called. It's actually a Public Service Training Center at 8:30 to give an overview of the criminal justice system for an hour with them.
Okay.
Then I come back here and we have our 10:30 to 11:30 here with them. In theory, I am in a civil trial calendar that day, but it's not going to be by then. All the stuff will be over. So we could take other pleas that day as long as you work with Ms. Nelson to make sure those people can be here. I can be here. I will be here. My Leadership Atlanta involvement is early, 8:30 to 9:30, and then the hour will be in here, and then I'm done with them. And then we have our monthly judges meeting. But when I'm done with that, we could, if there were other pleas you had.
We have a couple that we're working on.
Okay.
So.
That would be a great day.
Thank you. This is an little vacation. You so good.
She promises she's coming back. The fact that it's a cruise makes me more confident because that usually it stops where it starts. We're waiting on Ms. Willingham. She's in Judge Barwick's courtroom. You want to radio in to see? All right, great. How you been, Mr. Webb?
I've been doing good, Judge.
Good.
Dealing with sciatica.
Really?
Yeah.
Ouch.
Yeah.
Well, we're not as young as we used to be.
Exactly.
Those days are behind us.
Do you have an idea of what our tentative open date would be?
Have you learned has anyone reached out yet to say this is the other space?
No. So no one in our office knows anything.
Really? So you're like the source of info for them?
Yeah, because no one will tell us anything, and we're trying to make sure that we're not getting blindsided.
So, well, it's not blindsided because, well, people know something's coming. At least there's that. Yeah.
That is not being communicated with our office.
And when you say your office, meaning you don't think EXO knows, or
I'm sure we know.
it's just not getting deeper down than that?
Down
Okay,
to the rest of the staff.
got it. So the two new state court judges, they haven't been named yet. There's a short list now. There are 5 names that have gone to the governor, and he will pick 2. And I think the goal is for them to start January 1. And everything has to be happening then because they move into 2B and 2C. And if they move into those chambers, the magistrates and staff who are in there need to go somewhere. So end of year is probably a reasonable way to think about it.
One of those judges, either 2B or 2C.
When you say, are they hers?
Is that where she is now?
She's in 1A, 1B. She is moving also. That's part of this
Oh,
giant relocation.
that's why I was asking, because she had been over there, just kind of getting up.
Meaning in your space?
Yeah.
Yes, because she's trying to consolidate wisely. There she is.
Sorry.
That's all right. I blame Judge Barwick, not you. She's trying to get everyone in more or less one area, including herself and her support staff. So that's why. Is it like every day?
No, luckily she's not been in there, last week, but for a time period, she was in there at least more than once a week.
Yikes.
And so, we were getting a little bit nervous because it literally looked like she was kind of measuring things and was it just like a way to put the move outside.
That's funny. Are we ready?
Yes, sir.
Great. Mr. Jones, if you would please come up to the podium to join Mr. Webb. Yeah, if you flip around and then bend that microphone down towards you all, and it should be on green instead of red. If you put your, yeah, I think Mr. Webb knows how to, yep, you did it. Great. All right, Ms. Rivers, you ready?
Yes, I am.
Great. Well, let us get on the record. This is 25 SC 000679, State versus Ronald Jones. Mr. Jones is here in court with his lawyer, Mr. Webb. We have Ms. Willingham as the prosecutor. And Mr. Jones, my understanding is you're ready to go forward with a plea. Is that correct? Today is your final plea day, so you have the ability to withdraw your plea if the sentence that I impose is materially more severe than what Mr. Webb asks for. It may be negotiated, so both lawyers are asking for the same thing. But if it is X and I impose X plus something else, more community service or a fine or more time, you and Mr. Webb will have a chance to talk about it. And then you'll put on the record, well, I'm not thrilled, but I'm gonna go with that anyway. Or, no, thank you. I was ready to do this. And Judge, I respect your view. You came up with something different, but I'd rather go to trial. You understand that you'll be given that opportunity if I vary upwards from what Mr. Webb asked for.
Yes, sir.
Great. Ms. Willingham will put you under oath, ask you a bunch of questions. You need to answer those truthfully and completely. You also need to let me or Mr. Webb know if you've got any questions. Will you do that?
Yes, sir.
Okay. Ms. Willingham.
Please raise your right hand.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Ronald Edward Jones Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
39 years old, senior.
Are you able to read?
Senior in high school?
Yes.
Did you finish high school?
No.
Where'd you go to high school?
Edina High School, Minneapolis, Minnesota.
Minneapolis?
Yes.
All right.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? If you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with his services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I do.
Have you reviewed the indictment in this case?
Yes.
Do you waive formal reading of the indictment?
Yes.
Mr. Jones, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Do you understand that you are entering a guilty plea to the following offenses? Count 1, aggravated assault, family violence, which has a minimum of 3 years and a maximum of 20. Count 2, aggravated assault, which has a minimum of 1 year, a maximum of 20. Theft by taking, which has a minimum of 1 year and a maximum of 5. And possession of a firearm during the commission of a felony, which has a mandatory 5-year consecutive sentence. And I'm sorry, as to count 3, that count is actually being null-prossed, Your Honor.
The theft by taking.
Theft by taking, yes.
Okay.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 1 year? As to count 1, the state's recommendation is 5 years to serve 1 year. As to count 2, 5 years to serve 1 year concurrent to count 1. Count 3 will be null-prossed. And as to count 4, 5 years probation consecutive to count 1. You would be required to have no contact with the victims, complete family violence intervention program, complete a substance abuse evaluation and follow any recommendations, and have no weapons. And it is my understanding that your attorney will be asking for this to be a delayed reporting. Is that what was explained to you?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes.
Do you understand that if you do not accept the court sentence, you may withdraw your guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you on probation or parole for anything anywhere?
No, ma'am.
Do you further understand because this is a family violence conviction, if you are found in possession of a firearm, you could be charged on the federal level? Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am. I understand.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of aggravated assault, family violence, aggravated assault, and possession of a firearm during the commission of a felony in indictment 25 SC 000679?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the state would expect to show that on January 28th, 2024, the defendant and Ms. Joshua, the victim in this case, got into the back of a Uber. And while they were in that Uber, the defendant began striking Ms. Joshua, at which time the Uber driver tried, which is Mr. Ma, M-A-H, tried to get them to get out of the vehicle, but they did not. And ultimately, when he was able to get them out of the vehicle, the defendant then pulled out a firearm and pointed it at the Uber driver. Subsequently, Mr. Jones and Miss Joshua went into a apartment where the defendant then began beating on Miss Joshua there. And I'm sorry, I was trying to summarize it, and it was a Lyft, not a Uber.
Okay.
I have had the opportunity to speak with both Mr. Ma and Miss Joshua. Mr. Ma, as can be expected, because he was the driver, he's fine testifying if necessary, but he really doesn't want much more to do with the case. Miss Joshua is currently living out of state. She is fine coming to this state for a trial if necessary, but she wanted us to try and resolve it short of a trial. The initial offer we discussed was a 5-year to serve 2-year sentence. We went back and talked about, her and I had already talked about my bottom line would be the 1 year. So she is aware that that was a possibility for today. I did send her a text message this morning, but she is in a state that is very far behind us. But she knew that it was a possibility that it would be a 1 year offer by the time we got to today.
Okay. Got it. So she's been in contact, is willing to go forward, but if she could avoid having to relive it and come all the way here for that,
Yes.
she'd prefer that. Okay. And the connection is, as you understand it, or as maybe Ms. Joshua has explained, is that she and Mr. Jones were in a relationship at the time.
Yes, Your Honor, they were in a relationship at the time and they were living in the apartment together.
Where the Lyft took them?
Yes.
Okay. Do they have kids together?
No.
Okay. All right. Thank you for sharing that. Good morning, Ms. Jackson. Thank you for joining us.
Good morning, Your Honor.
Can you share any criminal history information you have on Mr. Jones?
Yes, sir. There are 9 cycles. The last arrest was October the 16th, 2024, out of Cobb County for possession of Schedule 1 or 2 controlled substance with the intent to distribute and possession of a firearm during commission of a felony. There was no disposition for that arrest. He does have 1 prior felony conviction. That was in 2015 out of DeKalb County for possession of marijuana with the intent to distribute. And there are misdemeanor convictions. One in 2007 out of DeKalb County for carrying a concealed weapon. One in 2004 out of Minnesota for possession of controlled substance. Nothing in addition, Your Honor.
Thank you, ma'am. Appreciate you being here.
Yes, sir.
Mr. Webb.
Good morning, Your Honor.
Morning.
Mr. Jones here today is here with his family who is in the courtroom. His two sisters and the mother of his triplets that he had recently in June of this year.
Which one had triplets?
Yeah.
Wow, congratulations. You look great having had triplets.
And who is the other gentleman? Oh, that's my nephew. And his nephew that's present in court. Your Honor, I am asking the court to allow Mr. Jones to enter this plea here today under the first offender. The other charge that was mentioned earlier, according to his criminal history, was done under 1613-2 in DeKalb County. I'm asking the court to allow him to enter this plea under the regular first offender. I'm also asking the court to tweak the sentence that me and the state worked out in this case. This would be the first Christmas where he would be able to spend with his triplets. One of the triplets has had complication, has been in the hospital since they were born. He has two boys and one girl.
And when were they born?
June of this year.
Okay.
I'm asking the court to tweak the sentence by allowing Mr. Jones to turn himself in after the holiday. I'm also asking the court to tweak the sentence to add the addition that he get his GED.
I already did.
Okay. And I'm also
Why we engaged about high school in Minneapolis.
And I'm also asking the court to add an additional requirement that he complete anger management. Through my representation of Mr. Jones and from talking with family members, we believe that this is the appropriate addition to the sentence that's been imposed by the state in this case. And Mr. Jones is accepting responsibility for what occurred on the night in question. It is my understanding that that particular night they were at a club. Someone put something in his drink. He gets in the car and he just loses it. And he hits the young lady and they go to this apartment complex that they shared at the time. And they have a fight. Police were called and he was arrested. He did spend approximately 31 or 32 days in custody. And for those reasons, that is why I'm asking for the sentence that we're asking for.
Okay. GED is covered. I'm curious if you know, Ms. Willingham, if there is a meaningful, I think there is, a meaningful anger management component within the family violence intervention program.
Judge, there is, which is typically why I don't ask for both.
Same. So I think you'll get it. I think it makes sense. I appreciate if families asking for it, they see things that I would never know about you. And I can see something from what this case is about. But family violence intervention has a bunch of classes. You will be going for a number of sessions, and there is a thread throughout it, nonviolent resolution of family issues, whether it's dealing with your kids, which you now have 3 of at least, dealing with the mother of the kids, with your cousin, with your nephew, with your parents, anything like that. So I'm not ignoring Mr. Webb's or your family's request. I just think that you will get, it's sort of like a multivitamin, family violence intervention. And if vitamin A was anger management, you're going to get a bunch of vitamin A in that multivitamin. I don't see a need to layer on top of that more anger management.
Yes, sir.
Mr. Webb, if you can get to me, well, let me ask Ms. Willingham, do you have any information about the DeKalb disposition, that it was a conditional discharge?
I don't, Judge.
Okay, so I'm actually not entering a final disposition until Mr. Jones turns himself in. So you're going to have a while to get to me a certified copy of the DeKalb case showing that it was a conditional discharge. assuming it was, do you have an objection to Mr. Jones using first offender?
No, Your Honor.
Okay, then we'll talk about that in just a second. And what's the state's view on a turn-in date rather than going into custody now?
Judge, that's fine. If this case, if we didn't plead today, it would have gone to the January trial calendar. But I recognize that if we did not start today, he would lose his final plea rights.
Okay. So we're going to do a turn-in date of January 6th, and I'll repeat that a few times. That's the first Tuesday in January. You'll be coming here when you turn yourself in. Don't bring lots of luggage or any watch or wallet or anything that you ever want to see again. Leave that with family, and you just show up in whatever clothes you don't mind if you don't see them again. But you come here, you're not going to the jail or anything like that. All right, let me march through a bunch of things and we'll circle back with that. First, Mr. Jones, do you have any questions about anything we've been discussing?
No, sir.
All right. Tell me about the triplets. It's 2 girls and 1 boy, 2 boys.
Boys and 1 girl.
And one of the boys is the one who's struggling a bit.
Yeah, since he was born, he had fluid on his brain, so they had to do brain surgery right when he was a baby. And then from there, he's been having severe seizures.
Okay.
And it was still going on real bad. They're trying to get him to a specialist so we can find out what's causing it.
But he's still in hospital.
Yes.
Okay. The other 2 are home and doing okay?
They're still in the hospital too because of respiratory. They was having breathing problems.
Okay. Were they preemies?
Oh, yeah.
Okay.
Considered that because they were so little.
Sure. So all 3 of them, but 2 of them, it's just the breathing. Otherwise, they seem like they're doing okay.
Yes, sir.
Gosh, but they've been in since June.
Yes, sir.
Okay. How often do you see them?
Just periodically. They let them out a little bit. And then when they breathing start going down, we had to hurry up and get them back in. So.
Okay. Is there any medical expectation as to when the 2 who are doing a little better could come home?
Yeah, we hoping for next week.
Oh, that's soon. Okay. Is the house ready for them?
Yes, sir.
All right. In that household is you and their mother, anyone else in the household?
Well, her kids.
Okay. She has other kids?
Yes, sir.
How many kids in the household already?
2.
How old are they?
21 and 17.
Well, that's a big gap.
Yeah.
And
I have other kids too. They're just older.
Okay. Your kids are like 21 is still living at home?
Well, college.
Oh, in college.
Yeah,
Great.
Kennesaw.
Good. All right. Your kids are also older?
Yes, sir.
All right. Are they local?
Yeah, one of them stay in Stone Mountain and my other daughter stay in Minneapolis.
Okay. And that's where you're from?
Yes, sir. Well, I'm from Indiana originally.
Oh, okay.
Yes, sir.
Got it. Well, I find there's a factual basis for your plea in this case, whether there was something slipped in your drink or it was just a bad day for you. What happened was dangerous. You're lucky the Lyft driver didn't have his own gun because someone's going to be laying on the pavement after that.
Yes, sir.
And I'm hopeful that Miss Joshua is doing okay. It sounds pretty scary for her. That's someone who is in your past. That's not someone you can reach out to ever again.
No, sir. I never had an episode like that in my life.
Okay. Let's hope there's not another one either. So there's a factual basis for the plea. Your plea is what I call knowing and voluntary. Knowing means you've understood what we talked about. You told me you don't have any questions. And voluntary means no one's forced you to enter this plea, but after having a chance to consult with your lawyer and your family, you've decided that this is the right way forward. Is that correct?
Yes, sir.
Okay. Tell me what kind of work you do?
Well, I'm a musician, I'm a drummer, and I also just got a job at Home Depot as well.
Doing what at Home Depot?
I'm working in the warehouse.
Okay. Not in a store, but at one of their distribution?
No, the store.
In a store?
Yes, sir.
Okay. Doing what? You like the hammer guy or the...
Stocking, just whatever is needed.
Okay.
But mainly stocking for now. I just got the job recently. So.
All right. Mr. Webb, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Willingham, can we sign for you?
Yes, Your Honor.
Mr. Jones, is it all right if we electronically sign your name to the indictment indicating your plea?
Yes, sir.
Okay, first offender. I don't know if you qualify for first offender. Assume you do. I'm not doubting Mr. Webb, but I need to see proof that your DeKalb County plea was what we call conditional discharge, where you pled to a drug case under a statute where it ends up not as a conviction for you if that goes well. Let me pause for a sec. Ms. Simpson, is Mr. Jones on probation in Georgia right now? Okay.
But to answer your question, it was an issue.
It was. It shows in your system as well.
I'm actually the handicap system.
Okay. All right. There we got our answer. She sees everywhere. Mr. Webb, what do you know about the Cobb case? Open, active?
It's open, Your Honor.
Are you the lawyer for him?
No, I was a lawyer on the conditional dismissal.
So you knew particularly well as well. Okay. But the Cobb case, what do you know about that?
Mr. Jones was in front of a liquor store.
Oh, I didn't mean what are the facts.
Oh,
I don't want him to admit to anything. But it's unindicted in Cobb and still could go forward is what I'm getting at.
It's indicted.
Or is indicted as a felony?
Yes.
Okay. But you're not, do you have a lawyer for that case?
I'm trying to hire my son. This is the only lawyer I ever used.
Ever had? Okay. Well, maybe Home Depot will give you a end of season stock bonus. And you can afford him. It just sort of makes the first offender exercise if he's going to be pleading to a felony there, but that case, something could happen to it. So, based on what I'm hearing from Ms. Simpson, we should talk about first offender. First offender is primarily an opportunity. If I sentence you as a first offender, Mr. Jones, then while you are under sentence, which you will be for a while based on these terms, if you're looking for work, you don't have to check that box that says I'm a felon. If you're trying to go back to school or do something else, the truth of the matter is you're not a convicted felon. It's an opportunity for which you just barely qualify, but it carries with it a risk. You're telling me very emphatically, hey, I've never done anything like this before, this situation with Ms. Joshua, I had issues before, and I hope that's true, but really I'm focused on what's going to be going on in the next 10 years because your sentence is 10 years long. If we are back together again in 2 years and the state shows me evidence that you put your hands on your child's mom in the wrong way and she called the police and she's got a bruise to show it, not only do you risk getting a revocation, but you could have your first offender status taken away. And without a trial, there'd be a hearing and Mr. Webb could represent you at it, but pretty low burden of proof for the state. I could resentence you. And based on these charges, we're looking at 45 years. So up to 45 years. I'm not saying I'd give you 45 years, but if it was a family violence situation where you mistreated someone important to you and made them scared, and heaven forbid you had a gun, because you may not have a gun while you're a first offender. You really weren't supposed to have a gun as a conditional discharge person, but maybe that sentence was over. But for the 10 years you're under sentence, no firearms. You're in the music industry, there are people around you, you can't be around folks with guns. So if you are arrested and you've got a gun on you, that's the kind of thing where I'm going to say, you misled me, you weren't ready for first offender, and I'll resentence you. You lose first offender status, and really without a trial, I said, with a hearing, you could be resentenced, and there'll be some prison time associated with it if it involves guns or threats or violence to folks close to you, really anyone else. Does that make sense?
Yes, sir.
So first offender is mostly a benefit, but it carries risks. Do you feel like you understand first offender?
Yes, sir.
Do you want to be sentenced as a first offender?
Yes, sir.
Okay, I will do that. And I will follow what has been negotiated here. Your sentences to count 1 is 5 years to serve 1 year with a balance on probation. You will get credit. You have to get credit for the time you've been in, which isn't much of the year, but it still counts. Your sentences to count 2 is also 5 years to serve 1 year. Count 3 has been dismissed. Count 4 has to be 5 years, and it has to run consecutive to the other counts, and it will. So the total sentence is 10 years to serve 1 year with the balance on probation. Special condition of probation number 1, no contact with Ms. Joshua. No direct contact, no indirect contact. If you guys have a mutual friend, you don't use that friend to tell her you're sorry or you're going to get her or anything else. If she shows me that you tried to contact her, that's the kind of thing that will make first offender end in a bad way. Special condition number 2, get your GED. You can do that while you're in custody. You can do that whenever, but you need to take care of it within the first year of your probation. Your probation doesn't start till you get out, but you need to knock that out within the first year of your probation. You also need to, within the first 4 months of your probation, enroll in the Family Violence Intervention Program. You'll need to complete it, but it takes a while. And so you got to enroll within those first 4 months and then complete it within the first year. What is the apartment complex you want him to stay? Or was it stay away from the complex, or was it just stay away from Ms. Joshua?
Just from Ms. Joshua.
That's easy. It sounds like she's far away, so no contact with her. Mr. Webb, what's your view on the drug and alcohol? It's just an evaluation. I didn't hear that was really at play here. It sounded like he had a drink that has something funky in it, as opposed to he had 18 drinks.
I would want Mr. Jones to get drug treatment.
Okay. So all I'm recommending, all I'm requiring is that when you are out, this is after you serve your time, you'll submit to a drug and alcohol abuse evaluation. And that's with a medical expert, a clinical expert who will talk to you about past usage and things like that. If that person recommends treatment, that treatment is also part of your probation.
Yes, sir.
I will waive your probation supervision fees for the first 3 months after you get out, just so you get on your feet. You've got a big old family you need to take care of, and you don't need to worry about those fees for the first 3 months. So 10 serve 1 is your sentence if you show up in my courtroom at 9 a.m. on January 6th. If you are not there at 9 a.m. on January 6th, there are actually going to be 2 things for me to sign. The other one is a 10 serve 3, not a first offender. I will sign that one at 9:30 if you're not here. If you walk in at 9:35, you got 10 serve 3, not first offender. Unless Mr. Webb is blowing up my office's phone saying he's on his way, flat tire, whatever. If Mr. Webb says you're on your way, you're on your way. But if I'm not hearing from Mr. Webb and you're not here and the clock strikes 9:30, I sign a document that is 10 years to serve 3 years, not first offender.
Yes,
That is the incentive for you to show up on January 6th.
Yes, sir.
If there are hiccups between now and January 6th, I reserve the right to impose 10 serve 1. I wouldn't change the sentence, but reserve the right to say, Mr. Webb, you got to bring Mr. Jones in because X is happening. I don't think that's going to happen. You're on bond, you're doing what you need to do. And most importantly, Ms. Joshua is far away, so she's not going to be reaching out to the prosecutor saying, he's in my front yard.
Yes, sir.
So you focus on the coming couple months on your household, and if 2 of your kids come home, helping them and socking away what you can from Home Depot and whatever you make as a musician. And I will see you when?
January 6th, 9.
9 a.m. here. Don't dress that nicely because you'll be going into custody, and we'll move forward that way. Ms. Willingham, anything else in connection with Mr. Jones's case?
Nothing further from the state, Your Honor.
Mr. Webb, anything else on behalf of Mr. Jones?
Nothing further.
Mr. Jones, anything else?
No, sir.
All right, good luck with those kids. They sound like amazing little guys. I hope they get better.
Thank you.
All right,
Your Honor, that concludes my business. May I be excused?
you all may be. Thanks.
Thank you.
So I do have a question.
Mm-hmm.
Hypothetically, if we unite case, and I think this is how it could go, if there's already a bond, can we just ask to, if we're not processed, can we just move that bond over and split it amongst any charges?
That's my objective every time. And what I've learned is it depends on the bonding company. If it is a private bond, I think with the sheriff's 10%, it's a lot easier to do that because there's no bonding company and there's a chunk of change sitting in the sheriff's office. And if we're not increasing the dollar amount, then they have the amount they were going to get.
That's my understanding also. I just wanted to confirm, but
Yeah.
we'll also double back with defense to confirm what their bond.
Yeah, and that, of course, you answered one of the variables in there, which is the state wouldn't be asking for a higher bond. Back in the McCauley era, we had a couple cases where she re-indicted and she was adding some serious stuff. And so she came in with a grand jury warrant, like, well, he already has a bond. Yeah, and it was child molestation, now it's aggravated sodomy. Oh, that's different. But like your situation where you're adding a theft, which is serious, I'm not minimizing that, But if the state doesn't think there needs to be a bigger, badder bond, then ideally we work with getting that bond to transfer over. Sometimes it depends on the age of the case. A bonding company will say, you know, the amount we got back then, they got to put more money up. And if that's what they need to do, they don't get a break because there's another charge in the indictment. Where it becomes real disruptive is if that person has to go back into custody and they need to generate more money, because that can sometimes take more time. And the state's intent wasn't, aha, I want to see you locked up. We didn't learn something new and scary. We just learned a little bit more. And so we're adding the theft by taking. So defense should talk with bonding company. And then I need to, hopefully there's a universal answer from the sheriff's office that if you are not increasing the bond amount, they're neutral to saying, all right, it was here, we just moved that same amount over here, and it backs a bond with a different set of counts.
Thank you.
Do you have that in mind for something here, or this was sort of in general?
This was for something here.
Okay.
Like maybe for something earlier.
Okay.
Just, it was my understanding, and that was what I was explaining to, ADA Smith, but I just wanted to make sure that I was correct in that.
Yeah.
That's what I think would be.
I would pose no obstacle. I think the issue would be the bonding agency. And like I said, I'm gonna check with the sheriff's team because I'd love to get that answer. It ought to be the same each time. Do you have we have, I think, 2 non-major case homicides.
Both of them.
You have both of them. Did we put both of them on one calendar then for you? I didn't know you.
No, I thought one.
Hairston?
I thought Harrison was gonna be December, and I thought the other one, from what I know, obviously religious placeholders, but it looked like the other one maybe had a tentative January date.
So the other one is the woman who supposedly shot herself in the head in the back of the car. We may have put both those on. The only December trial calendar in here is, well, but it's a special setting of one of Adam's cases that's gonna go. Cool. But I asked Ms. Nelson, I said, don't put another Adam murder on, but don't we have to? I thought Ms. Charles had one of them.
So technically, yes. And I know she really does still want to keep it.
But she's always doing
Your cases,
swamped.
they have less people than us, so.
Yeah. And that week that we've got this specially set calendar is one of the Emerson weeks. So, but I was thinking I might put Hairston and or Dominique, or what was the name of the, well, you know the case.
Yes, right.
Yeah, we would put either Hairston or Wright on the Emerson calendar. So we've got it in 2 places.
Well, and if that's the case, I will definitely be trying Harrison.
Okay.
But if Wright is also going to be on consolidated,
Well,
I can just let,
I'll only put one. If you've got both, I'll just put one of them.
Harrison, I'm definitely gonna try. That family they were extremely excited when I came back, so.
Good.
I'm going to.
They should be, and they should be frustrated that through no fault of Mr. Hairston's, it's been such a windy road with the representation piece.
But they've been troopers. They've been very understanding to all of it.
Yeah.
They were actually kind of happy that we got continued off the November calendar, so they were able to celebrate her birthday.
Oh, okay. Well, good. All right. Well, we'll sort that one out. Thanks. All right. Thank you, Ms. Jackson and Ms. Rivers. You guys have a great day.
Thank you, you as well, Your Honor.